and Happy New Year, everyone. I'm sorry for the delayed start. Welcome to this consultation hosted by Doughty Street Chambers, the European Coalition on Corporate Justice, Friends of the Earth Europe, and Global Witness. My name is Krishnendu Mukherjee, and I'm a barrister specializing in business and human rights. The last 10 months have exposed the most vulnerable in the developed world to the fragility of the lives led by many in the global south. We are again grateful to the European Union for leading the state's response through a proposed systematic change in the obligations of business entities to human rights violations to which they contribute. The purpose of this consultation is to provide a view from the global south on how an EU mandated law could be most effective in 3 cases which illustrate violations which broadly occur from the start of the business activity, during the business activity, and following the end of the business activity. We are again very grateful and pleased Ms. from the Commission has been able to join us. And we welcome JB Garganera from the Philippines, Dr. Rana Sengupta from India, and Chima Williams from Nigeria. By now, all of you will be very familiar with Zoom. Those who haven't, you will notice that your mics are muted and your videos are turned off. And so this is a presetting, just stops any background interference. Each presenter will present for about 15 minutes, after which if Ms. Boozer has any questions or clarifications that she wants to add, please feel free to do so. And at the end of all the presentations, there may be some time for some questions or comments from the participants. We're recording this webinar or consultation, and a copy will be available on the Doughty Street website after we finish, for you or any of your colleagues unable to attend. So I think I would ask all the participants other than JB and perhaps Ms. Boozer to switch off their videos, and for JB to speak on 15 minutes about his case. Thank you very much.
Thank you. And good day, good morning, good evening to everyone. I am JB Garganera from the Philippines. It's an honor to make this presentation to this panel. I come from an organization called Alianza Tigil Mina, Alliance to Stop Mining in the Philippines. We are an alliance of more than 100 organizations that are collectively challenging the policy and practice of destructive mining here in the Philippines. Half of our members are from the affected communities themselves. Day in and day out, they are confronting the destructive practice of mining in their areas. The other half of our members are NGOs, legal groups, human rights groups, faith-based groups, academe that are providing direct support to these affected communities. I am going to present a case of the Didipio mines up north in the Philippines. This is an interesting case because it has been subjected to a series of human rights investigation, and it has a landmark decision from our national human rights institution, the Commission on Human Rights on the Philippines. But and then I would like to share some of the lessons in this almost 3 decades of struggle, and this is representative of the kind of risks and vulnerabilities that environmental rights defenders are facing here in the Philippines. So the Didipio mine is up north in the Philippines. It's owned by an Australian-Canadian mining company, but we know that there are financial investments from European instruments. They're also very active in the London Metal Exchange. This is technically Financial Technical Assistance Agreement number 1, meaning this is the first large-scale mining contract after our mining law was passed in 1995. So whatever is the behavior and whatever is the development or evolution of our government and how communities engage with this mining project, it is always setting the precedent because it is the first large-scale mining contract that has been approved by our government. As a mining contract, it has a 25-year mine life. But for 18 years, communities and even local governments successfully struggled and prevented the commercial operations of this mine. But it was only able to operate on its last 7 years of contract. This mining contract ended in 2019, and since then, the mining company had wanted to open up with a new mining contract, but this has been prevented by the local government and communities who are resisting. In a nutshell, there have been a lot of investigations, and even our Commission on Human Rights, in after investigating for 2 years, established that in at least 7 instances, both our national government and the mining company failed to promote, protect, and fulfill their human rights obligations. And in fact, the company in at least 3 instances abused the rights of the affected communities. I will not go into the details. We can submit a written note and some references to the commission for more references. But let me just enumerate in concrete terms what are these human rights violations. The mining company demolished illegally 187 houses in their mining area without compensation. And the illegal houses were demolished because the families refused to leave their farms and their ancestral lands. The mining area is in a watershed, and it is part of the indigenous lands of indigenous peoples. By law, a watershed should not be open to any extractive project. And since it's in indigenous land, the consent of indigenous peoples should have been secured. These are the reasons why for the first 16 years of the mining contract, the mining company couldn't enter because they lacked the consent and they could not prove that they will not be destroying the watersheds. Therefore, farmers, local government unit officials, elected officials, and indigenous peoples successfully prevented the entry for 16 years. However, when we had a change of administration sometime around in 2012, the company was able to exert influence at the national level and forced its way in its last 7 years of operation. When the mining contract of this company ended in 2019, immediately the local government instructed the local police and the communities, we will not allow the mining company to operate, and a people's barricade was set up in two of the main gates of this mining company, supported by local governments. And for more than 12 months, the mining company was not able to make any illegal activity in the area. However, on April 6, 2020, at the height of the COVID-19 lockdown, two fuel trucks of this mining company forcibly entered and dispersed the peaceful people's blockade and made illegal arrests of two leaders. And there were some injuries, including indigenous women, who tried to prevent the entry of the fuel truck of the mining company. That forced entry was just the latest horrible and violent attempt of the mining company to force its way and disregard the will of the people. Imagine, from the common farmer up to the provincial governor who were against its mining operations. it took the influence of this mining company to ask our Minister of the Local Interior and Local Government and the Minister of Environment to get in special permit to allow its fuel trucks to enter. As I've said, there have there was a landmark decision of the Commission on Human Rights about this case, and this is one of the first few instances where we are able to do a human rights impact assessment. This is far from the human rights due diligence that is being proposed in the EU legislation, but it is the nearest that our country and our civil society has been able to come up with a measurement on how a company is doing on its human rights obligation. Let me now use my remaining 6 or 7 minutes to share some of the lessons in our continuing struggle, which may be useful in the continuing study and debate of the EU Parliament on this legislation. First, when you try to discuss corporate responsibility to respect, which is one of the pillar of the Rugi framework, it must be clear that the legislation should create the responsibility that the corporations must respect all the laws and all the rights of the stakeholders. It cannot just be that the corporations will be respecting those laws that it will claim are the only laws that are applicable to them. So, for example, in our case, we have always said the mining company and the mining operation should comply with our environmental laws, with our indigenous laws, and cannot always invoke they are just merely following the mining law. So this legislation should create that framework that the corporate is responsible and should comply with all existing laws. Second, we should not pay lip service only to community consultations or acquiring social acceptability or the social license to operate. In many instances, these community consultations and social licenses are openly violated, disregarded, or sometimes coercion is resorted to by mining companies. Corporations must genuinely acquire these social licenses, and special attention must be given to indigenous peoples when we invoke the concept of free, prior, and informed consent. I would like to take note that even the ICMM, the International Council on Mines and Metals, recognize free, prior, and informed consent. But this has not been evenly implemented in all mining host countries. If the ICMM has recognized FPIC, then I think states should make FPIC or free, prior, informed consent as a common legislation and a bottom line, not anymore an aspiration. Third, our experience has been companies are very powerful. They have the money, they have the influence. And in our case, in the Philippines, I mean, I can name senators, members of our Congress, provincial governors who are beneficial owners of mining companies. They either their family own the company or they are major stockholders or the mining company financed their electoral campaign. And so you have this collusion of the powerful political elite are the same ones who are running the extractive companies. And how do you expect Congress or our executive department to give an impartial and objective investigation when human rights are being violated? Fourth, we strongly recommend that human rights due diligence should be a minimum requirement. You know, compliance with international standards and multilateral agreements must be done. There are several tools already being proposed and being tested on human rights due diligence. If a mining company or any other corporation can practice due diligence, accounting due diligence when mergers and acquisitions are being done, any corporation should be able to do a human rights due diligence when their impact on communities are so severe and if there's a high risk of abusing and violating human rights. Fifth, we strongly suggest that the concept of no-go zones be recognized, whether national laws or as standards by international organizations or even the UN. There are certain areas that should not be open for any extractive project or any destructive project. By the unique topography or geography or cultural value, some areas should remain closed. And watersheds, for instance, or fragile island ecosystems. I mean, we don't expect mining companies to mine the Vatican City because of the cultural value of the Vatican. A sacred site for an indigenous community is as holy as the Vatican, and those kinds of free, prior, and informed consent should be recognized and respected. I know there are a lot of mining laws in other countries. We have one in the Philippines that actually specify areas close to mining. But even mining companies violate that same section in the mining law. I think one last recommendation is, and still consistent with the Rugi framework, any legislation should improve the efficiency and effectiveness of any grievance mechanism. If we are going to really be giving genuine hope to affected communities, there must be an effective grievance mechanism. One last point before I use up my 15 minutes. I really have to say this. One external factor that is really creating a massive influence on the pace of investments and the behavior and attitude of corporations are free trade agreements. If these free trade agreements give corporations the power to sue our governments when we change our laws or when we become more protective of our human rights, why is it that we or even our governments cannot sue corporations? And that is because in our free trade agreements, there's a provision of that. It's really illogical why our my government is afraid to change our environmental laws because a group of international mining companies threatened to sue our government that we will be taken into an ISDS case. That threat alone forced our Minister of Finance and Minister of Environment not to proceed in crafting new environmental laws in light of climate change. And so I think when the EU tries to discuss this new legislation, the element and the impact of free trade agreements should also be factored in. Thank you very much, and I'd be willing to share any more details later.
Thanks a lot, JB, for keeping to the time and also providing us with a very interesting case study and the number of issues that are around it. That's very helpful. I wonder at this stage whether, Ms. Boozer, you have any clarifications that you want to ask or any short questions. Hopefully we'll have time at the end of the three panelists. You're on mute. Yeah.
Thanks. No, this I have no questions. It was very clear. Thanks a lot for the presentation.
All right, thanks. We'll then move on to my longtime friend and Chief Exec of Mine Labour Protection Campaign in Rajasthan, Dr. Rana Sengupta. Rana, are you there?
Yeah, hi.
Hi. So your 15 minutes start now.
Okay, I'll give you a brief about the mining scenario in Rajasthan, and that is in the initial years, that is around 1950s, when the system was the central government used to take care of the enforcement of the Mines Act, and the state and various states in the country were mining, and they were mining corporations of the public sector enterprises. That was the scenario where things were okay, but over the years, when the state government started giving out the leases to private players, that's where the enforcement system was the same, but the number of mines that had to be inspected went from 1 to 33,000 as of today. And the problem, which is very extensive, is now with all those minerals which we call dimensional stones or natural stones in the current scenario. There are around, for an example, in Rajasthan, there are around 3 million mine workers. And that is the area where the problem is. Not a single mine in Rajasthan keeps records of the mine workers. There is a mechanism through which they are supposed to maintain records of workers, and that has to be inspected by a Department of Labor. That is a central act. That is with the central government, which doesn't even come to know how many mines are operating and who is operating the mines, because these 33 out of 33,000 mines, approximately 90% of the mines have not even informed about their operations to those concerned authorities who are supposed to ensure the compliance of the Mines Act and ensure the rights and due diligence of the workers. This is the gap which we found and discovered over the years when when there were high incidents of deaths among mine workers, and we found that around 37% of the women mine workers were widows of mine workers. In a study which we did in 2009 approximately, we investigated into the matter, and when we asked the widows what was the reason of the deaths of their husband, they would say it was tuberculosis. And the report we submitted was also based on the testimonials where they said that most of the mine workers have died because of tuberculosis, which was challenged. And on further investigation, we found that it was actually not tuberculosis, but it was silicosis. And neither the mine workers were knowing that they were suffering from silicosis, nor were the doctors aware that they had to notify such diseases to the concerned authorities so that the regulatory authorities could come and do their interventions. 2010, the case was put up with the National Human Rights Commission, which intervened and investigated into the matter and found the fact that yes, these mine workers, most of them who were suffering from silicosis, were misdiagnosed for tuberculosis, and those who were even confirmed suffering from silicosis were not even notified with the concerned authorities. So the mine workers were deprived of their due compensation, nor they could go to any courts because there was no evidence of their employment. There was no records maintained, which forced the state government to start paying off monetary relief to the mine workers. Approximately 30,000 people have been certified suffering from silicosis, and most of them have been given monetary relief. But the dilemma is, despite of now having a proof that people are dying out of silicosis and they have been given enough monetary relief by the state government, which actually they were entitled for compensation from the mine owners, not a single case of mine worker has been able to receive their due compensation till date. So what is the gap? Why is it such a chaos? Because the state government's direct stake is with the revenue which they earn out of mining, and the enforcement is again with the central government. The central government has nothing to do if their inspection reports are not even complied with, and the state government doesn't bother to do it. So when we took it up with the issues with various other courts, okay, including the State Human Rights Commission, that's where the State Human Rights Commission understood that there's a big gap between the way the state and the central government is operating, and they facilitated dialogues between both the departments of the state government and central government. But again, till date, the problem is the mine owners get away by operating the mines without even informing the central labor department of the provisions and the mandatory norms that they have to follow. At some point of time, there were some researches which were done by credible organizations like SOMO, CREM, and many other organizations from Germany and European countries. They also highlighted the problem. But what happened was, there were companies which were facilitating some certifications and also some dialogue between all the parties, they could take the they basically started taking support of the companies on the other end, because what they were claiming was the problem is in India, and the problem, and what they are trying to do is they are recognizing the problem, but they can't help it out unless and until the government themselves try to do to the local government themselves try to investigate and intervene into the issue and solve it. So as I said that despite of the problem of silicosis being exposed, recognized, the state government has listed the problem as an epidemic, which is the first state, the Rajasthan government is the first state to do that. So there is a lot of response from the state government, but that response is towards rehabilitation or relief. They are actually voiceless and silent in terms of ensuring prevention and compliance. So what we have been asking to European companies as well as other American companies is, what the answer is, even whether it is domestic big players, that try to see that you do business with only those companies which comply with the local norms. There are set of rules where both where the accountability of the company is set with the central as well as the state government. If that, or only with those companies the trade should be promoted, so that the workers interests are secured, because the shift of mining from the state government to private players was in the greed of extracting minerals and the greed of earning money. So there was no mechanism where mining was given out to credible institutions or those who were qualified to operate. Initially, it was given through lotteries, and now it is given out through auctions. So you don't, what is your credibility? What is your qualification to operate a mine? Is it just your money or your fate to operate, to get a mining lease? Or there should be some mechanism where you ensure that the mines are operated by qualified engineers, technicians, and all those norms which are there in the Mines Act are being complied with. So starting from basic registration of the workers to ensuring welfare. There is a big gap also where the central government who says that they are only there to ensure compliances, they can't ensure welfare of the workers because the revenue is with the state government. So we did a consultation around 1.5 years back, where we were demanding for a mine workers welfare board, similar to the construction workers welfare board which is there in the country. And then we also thought that even if there is money with the state government and a welfare board is established, how do we ensure compliance and ensure that they get their due entitlements, okay, and there is compliance of law. So what we are coming up right now is either there is a change in the act, the Mines Act, which we see very difficult to happen, but at the same time, if for the due diligence, if we can establish a local commission within the state's purview, which can ensure welfare through the funds that they have out of the revenue which they have collected, as well as have a joint uh, intervention to ensure that the rights of the workers are protected. So uh, our appeal, whether it is for the domestic companies, domestic buyers or international buyers, is the situation of the mine workers are grave. They are indebted, most of them. There is forced labor, there is child labor, and the working conditions are very unsafe. So it's a joint responsibility that we should take up and ensure that only those companies we trade with only those companies which adhere to the due diligence, which are registered with the concerned authorities which are supposed to do the regulatory part and protect the health rights of the mine workers, their families, and the community at large. And as well as that, because there is no case till date that has been registered on any form of violation with the lower courts, because there is no record of the mine workers, only there is a figure around 3 million workers are there in the state of Rajasthan which are working in the mines. We also want to see that there is a effective grievance mechanism that is established. So in a nutshell, what we are advocating as of today is we have a mineral policy which is devised, amended, and revised every 2 years by the state government because they want to explore more minerals, more conservation, more revenue. But what about the other issues? Whether it is human rights, whether it is environmental protection, it is environmental justice, child rights, everything, fair trade, business and human rights, all these factors come up from different windows. So they are only bothered about their revenue. So, and that is just because they have a mineral policy. What we are advocating for is a mining policy. Let's have a comprehensive policy which takes care of all the players, all the stakeholders, so that we respect each other and see that this industry goes forward in a credible manner. And those, whoever is trading, they see that they are accountable. They are also involved in the process to ensure that things improve from what they are as of today. So with this, I would like to end my note and thank you all to give me a patient hearing.
Thanks, Rana. And maybe even a human rights and environmental policy as well would be quite important. And we can see some commonalities, I think, between JB's case and the situation in Rajasthan also occurring. Ms. Buza, do you have any questions at this stage for Rana, or shall I move on?
Yeah, just probably a quick one. Indeed, as you first take consideration, indeed, as you were saying in the two case studies that you presented, and thanks for that presented, there is a strong link between human rights and environmental rights. And this is why also, in our view, the scope of the initiative should look at risks, both when it comes to human rights protection and to environmental protection, because we see the two as being strongly linked. In terms of questions, I understand the point. Just to explain, probably is better. What we are trying to do is and there is still a consultation ongoing, so I cannot say much because most of the choices have not been made. But the instruments of which we are.
Sorry, because we have another speaker. Do you want to maybe just before?
Yeah, no, just. If I can just briefly, because it's linked to one of the explanations, it's, I was saying the idea is the orientations on which we are thinking is to think about a due diligence duties for the companies to also control the risks in their value chain, and to identify and control the risks in the value chain. So when it comes, as I was saying, to human rights violations and environmental rights, etc. So in this, of course, by controlling the risks, the companies can choose the providers that pose less risks, i.e. that are compliant with the laws. But we cannot, it's not in our hands to explain to the companies which suppliers they can choose. So I just wanted to ask a bit, like, how to make sure then, if in this logic that what the companies have to do is to make sure that there are no risks, how would the speakers see that they choose like the right suppliers?
Can I answer?
Do you want to? Shall we just think on that a bit and maybe answer at the end? I'm very keen to bring Chima in, and maybe he'll have something to say about that as well. So Chima, do you want to start your presentation?
Okay. Thank you, Ms. Buza, for this great opportunity. I'm delighted once again because these issues have been canvassing before the European Parliament since 2008. And I am happy that some of the things that we've been saying and discussing are now being taken on board somehow with this due diligence proposal that is coming up from the EU. By way of introduction, I'm Chima Williams. I'm a lawyer by training. I'm the acting executive director of Environmental Rights Action Friends of the Earth Nigeria. Environmental Rights Action Friends of the Earth Nigeria is the Nigerian chapter of the global grassroots environmental justice network, Friends of the Earth International. Our sister organization, Friends of the Earth Europe, is part of this process. And I've been on this turf with the Friends of the Earth Europe and ECCJ over a long time. And for these, I have many cases, but all are centered on environmental liability, environmental destruction, and the attitudes of the corporations, most of them of European origin, their behavior. I will cite two cases. One is a case, both of them are ongoing anyway, and I would be very careful not to make any statement that will be sub judice or considered sub judice, because one of the cases in The Hague, we're expecting a judgment on the 29th of this month. So I wouldn't say anything on that that will be prejudicial or interpreted to be prejudicial. And the other case is the case that has set the global standard from the South on issue of looking at environmental rights violations as an exacerbation of the incidence of climate change. And that is the case of John Agbemre against Shell, where John Agbemre, a community person representing his small community of Iwerika in Delta State, Nigeria, had sued Shell and their Nigerian joint, and at the outset, the Attorney General of the Federation of Nigeria for violation of their rights to life and rights to dignity of the human person. And these rights, were attributed to partly the contribution of gas flaring to the incidence of climate change, which is regarded as a local action with global impact. And this is where all our work have come to be synergized, that whatever we are doing here affects others. So if we have to solve the problems, it must be concerted efforts by all, because nobody is spared, as we have seen in recent times, that even those climate deniers have seen that climate change is real, because the impact knows no boundary and it respects nobody. Okay, so the case was brought to the court in 2005. That's today 16 years ago. And the court gave an order that accepted that continued flaring of gas in the Iwerekan community violates the citizens' right to life and dignity of human person, and ordered for its stop, immediate stop. But unfortunately, the company that is at the behest of it, Shell, continue to flare gas in the Iwerekan community. And when we tried to expose in 2008, I led a team of journalists and environmentalists and community people to expose Shell's continued flare of gas in the Oregon community in defiance to the order of the court in 2005. I was arrested with all the journalists and all the community people, including members of their host community from the Oregon community, were all detained in Shell facility. Okay, so, but continuing, Shell lived in denial of the existence of the judgments with all the legal gymnastics that happened. But notably, about 12 years after, in 2018, Shell dragged us back to the Court of Appeal to ask the court to look at the judgment of 2005 that it had denied always from 2005 that it no longer existed. And here, everybody's hands were tied. And nobody could compel Shell to do the right thing, not even government, because as the case is almost the same as have been narrated by my co-panelists from India, from Pakistan, is the same thing. The governments are, their hands are tied because these corporations seems bigger and stronger than the governments. Okay, and this is where, for us, we think that, yes, in Europe, their home countries, the home countries of these companies, they try to respect the laws, they try to respect the rules, probably because of other factors of institutional strength in these countries, which may be lacking in, in the South. So this is where we want the European Union as a body, to help these weaker countries. Okay, I call what countries weaker countries because the resources they depend most of them to run the affairs of states somewhat
you're cutting out very bad.
To an extent from the activities of these multinationals, whom the citizens, where the strengths and weaknesses lies, and from these countries where they respect institutions. Okay, hello?
Yeah, hi Chima.
Can you hear me?
Yes, we can hear you, but not very well. The connection isn't very good. So perhaps you can stop there now. And thank you very much, Chima, for telling us about the situation with oil companies in Nigeria. Perhaps we could just go back to.
Sorry to you.
We can't really hear you, Chima. I'm sorry, the connection isn't very good. Perhaps if you put your video off. No, you've gone.
Okay, let me try that and see if it's better.
All right, do you want to just finish off now? Because
okay, is it better now?
It's still not very good, but perhaps we just finish whatever you wanted to say. Chima? No, he's gone completely. Chima, your connection isn't very good. Perhaps I can just then.
I will ask. Okay, what we'll be asking from.
Go on. Chima?
Yeah. Am I okay now? Am I better?
Yeah, you're better. Just one sentence, please.
Okay. One sentence. Want to help us consider supporting the UN system to set up an environmental or a treaty, legally binding treaty that will determine legally the rights of citizens in environmental pollution matters, and to help us look at the issue of evidence gathering, because the poor community people don't have the resources to gather evidence in litigation against the super power multinational, so that it can be the evidence provision can change to be a violator. The onus should be on the company to prove that they are not in violation. And thirdly, issue of jurisdiction, making it possible. I know that with the case in The Hague, we have been able to establish jurisdictional rights of citizens from host countries to bring out extraction, at least from our case in The Hague. So we want the EU to make this into a law that in all European countries, this should be practicable. I think I can take questions if
Thank you,
communication.
Thank you, Chima. That was very enlightening.
Thank you.
Just to let the participants know that we've actually sent the Ms. Booz and the EU Commission briefings on all of the case studies this afternoon, with all the recommendations for the new EU mandatory law. But can I just turn to Ms. Booz's point, which I think you were all considering while Chima was speaking, which is, what can the law require buyers to do in a situation where, as we've heard, there are suppliers who don't comply with the law, or in some cases, most suppliers don't comply with the law? What can the law mandate EU companies to do? I think, Rana, you wanted to answer that to begin with. Are you there?
Yeah. Just one recommendation on that. As there is a complex situation in specific to the case of Rajasthan, where the mining is a state subject and the enforcement of all the provisions to protect human rights and the labor laws is with the central act, is a central act, and lies with the central government. What we would recommend is that it should be ensured that whichever company which is being traded with should be registered with all the regulatory authorities or various departments which protect the environmental laws, the human rights, the occupational health and safety. So it's just not the mining department issuing a license to a mine owner and there are the companies who are trading with them. They should ensure that this particular mine which has been given a license should also have been registered with all the concerned authorities which are supposed to do the regulation and protection of human rights and other provisions. So only those companies should be allowed to trade with. If that is done, this will set an example not only for the international players, but also with the domestic players, that there are several other institutions which are there to protect the rights of the communities and the mine workers. They should be there in the picture, and only those companies should be traded with. This is my recommendation.
JB, yes.
Thank you. I have three suggestions. One, the legislation can suggest that there is a menu of available approaches that corporations can explore. One would be self-policing. And then we can take a look at existing practices and methods where industries are actually trying to police themselves. So for example, in the mining industry, when they took at the supply chain analysis and they want to project the image that they are complying with environmental, social, and governance standards, there are existing platforms and tools. The Kimberley process, which was a result of the blood diamond issue. Then there's the Clean Gold and Green Gold initiative, wherein the sellers, eventually the retailers of gold jewelry, want to make sure that from the mines up to the processor up to the buyers, there is a process of self-regulation and self-reporting. And then there is some labeling that this underwent a clean or a green gold process. And then eventually that is actually an incentive for corporations, because with that label of a clean or green gold initiative, they can actually command a better price than the regular gold jewelry. But I guess one of the better standards right now, which might be useful, is EITI. The focus of EITI is to make sure that the whole value chain of the mining company practices transparency on their tax payments, financial investments, even to social development. If we tweak that, use the models and even the approaches and the existing tools, and maybe overlay a human rights perspective, I think it's a very interesting proposal, at least for the global mining industry. A second set would be a certification model. If a if the states or the EU could come up with a certification that this practice of corporate behavior is maybe some sort of excellent or very good. So there's a grading, a certification process that will compel corporations to really say, this makes business sense. I will have to comply with this. Otherwise, I will lose out on the market. So of course, that has to be well done. But I think to reduce, first, the legislation must balance what is it that the corporations will fear losing if they do not comply with their whole supply chain in observing or protecting human rights, and what is it in it for them to be identified or labeled as compliant to human rights standards.
Thank you, JB. Chima, I don't know whether you can hear us. Is anything that you want to add to that?
Yeah, I can hear you. In addition to the suggestion Gupta had made, I will want us to look at incorporating into the rules parent company liability, okay, for violation occasioned by their daughter companies. If the parent company knows that they will be liable wherever they operate, they will make sure that all the safety guards that have been highlighted are followed. So I just want to flag that. If that can be integrated, that would be very, very useful.
Thank you very much. And I'd also add to that, Ms. Boozer, the recommendations that are made in the independent review of the Leicester garment factories by Boohoo, just to show that it's not countries in the developing world or in the global south that don't enforce the laws. Even in the UK, the British government didn't enforce working conditions in Leicester garment factories, and an independent review of that has made a number of very important recommendations in relation to lists of suppliers, certification, and companies' own inspections, which I will send you the link to that. It's 8 minutes past 3 here in London. I think perhaps just one more question from you, Ms. Boozer. I'm sorry we don't have much time today, but if you have any other issues you'd like to raise with the panelists.
Yes, maybe just also to hear a bit their views on what are also in terms of somewhere already mentioned, I think, the constraints in terms of accessing to justice and what are the solutions also that you could envisage. I think somewhere already mentioned, but if you have any other.
The question was about access to justice and what mechanisms could be used.
Yeah.
You all, I think, highlighted in your various presentations the grave difficulties, serious difficulties in accessing justice domestically and transnationally. So maybe if you could give Ms. Boozer one takeaway. JB?
Yeah, and I think a similar question was posted in the Q&A box, and I typed in some answers, but let me share this. I think number one, should consider 3 things you can consider. The state should establish a center or agency that can actually receive, study, and investigate complaints. You know, it will not, affected communities will not take the first step if they don't have any agency or office that they can approach to. That's a very important step for affected individuals or communities. They must know that there is an office or an agency that they can go to and file a complaint. Number 2 would be NHRI should be given an expanded mandate and budgets so that they can perform that expanded role. Essentially, NHRIs are still, and states are the duty bearers. So it's basically a question of expanding the capacity and mandate of NHRIs so that this additional mandate of monitoring the behavior of corporations becomes part of the regular duty of the NHRIs. This is a long shot, but this is one of the main calls of the global campaign for a legally binding treaty. A tribunal that can hear cases and resolve these cases should be explored. And if an experiment can be done as part of the legislation or outside of the legislation, as long as we explore this possibility, that sends a powerful message to corporations. Maybe a good way to start is a quasi-judicial format of this. Doesn't have to be the formal court system, but maybe we can be more innovative in a quasi-judicial format.
Chima?
Okay. On access to justice, of course, the starting point, what I would suggest would be looking at the issue of access to information. Because when you do not have information, it's difficult for you even to understand whether justice has been meted or not. Okay, so the Commission should consider including a provision that compels all companies to provide information about their activities, their operations, you know, within the value chain in the production system, and as it affects and is as demanded or requested for by victims, because that can help. One way, there's some information that could be made available to them, a smoother opportunity for reconciling issues into account the grievance mechanism that Jane talked about, okay, which will be internally handled. But in the absence of information availability, citizens or victims will take, including taking laws into their hands for with everything. Okay, so I want to flag out that the access to information is critical to access to justice.
Absolutely, absolutely. Rana, do you want anything to add?
Yeah, because I said that the case of Rajasthan, the issue of Rajasthan is very exclusive and very unique in this particular instance. So we have a very special kind of recommendation to this particular point of access to justice. The onus of informing the operations of the mining operation lies with the mine owner as of now in the current state of Rajasthan. And that is why most of the mine owners are operating without intimating their operations to the concerned regulatory authorities. What we would propose is it shouldn't be voluntary, it should be mandatory, and it should be a part of the lease deed, the mining operations agreement, that without intimating the operations to all the concerned authorities, regulatory authorities, no mining operations should be allowed, which will then let all the mine workers come to know which are the concerned authorities which are there to protect various rights of theirs. At the same time, whenever the regulatory authorities inspect and issue notices of any form of violation, immediately operations should be stopped and the mining department should be asked to provide a action taken report. Instead of asking the lessee or the mine owner to provide an action taken report, who very smartly goes away without doing it, the onus and the responsibility of providing an action taken report should be put up with the concerned authority which has issued them the leases, so that all the three parties function together. The one who has given the leases or the power to mine, the one who is mining, and the authority which is supposed to ensure and the regulations and ensure that all the rights of the workers are protected. So that is how the access to justice can be ensured in the particular case of Rajasthan. Thank you.
Thanks, Rana. It's 3:15 here. Ms. Boozer, do you have any other questions?
No, thanks. And thanks a lot to the speakers for the valuable presentation and the valuable input. I take note of the problems identified. I have to say that some of them, I mean, again, the initiative on which we are working is going to be a company law initiative. It will concern the duty of the companies to identify, assess, and mitigate risks in their value chains. There are some of the issues that could be addressed with this system, others that go beyond, like as one of the speakers mentioned before, may concern trade agreements, trade issues, and etc. So it's the scope of the initiative is limited in what we can do. But certainly the ideas that you have provided are helpful for me, and we reflect upon them. And if I don't know if already done, otherwise I would recommend that you also reply to our public consultation and set out your ideas in that respect.
Perhaps you could just remind the participants of the time scale.
It's the 8th of February.
And then after that, what's the process after that, just briefly, so that
yes, after we close the public consultation, then we will assess the feedback that we receive from all the stakeholders, so NGOs, also companies, national authorities, etc. And then this will inform our assessment. And there will be also an impact assessment of the ideas that the Commission will put forward. And finally, there will be a legislative proposal that is foreseen for the first half of the year, to be a proposal to be adopted by the Commission. Then there will be the legislative procedure will start with the discussions between co-legislators, the Council and the European Parliament.
Okay. Thanks for clarifying the process, and thanks for saying that the consultation was useful to you. I'd like to thank you, Ms. Boozer, and I'd like to thank all of the panelists here today, JB, Chima, and Rana, obviously, for their contributions, and to the participants for your participation. In these uncertain and dark times, one thing is certain: unless we communicate and learn across boundaries and environments like we have today, we will not be able to build a more resilient, sustainable global society. So thank you for doing that. Many thanks. Stay safe and stay positive, and Happy New Year. Thank you.
Bye.
Bye.
Thank you. Thank you.